Hi guys, welcome back to my channel. For today's video, I will be sharing with you the K1 Fiance Visa frequently asked questions. Now just a disclaimer, I am not an immigration lawyer or expert, and my comments should not be considered legal advice. For personalized guidance on your specific immigration situation, please consult a qualified immigration attorney or expert. I am not responsible for any actions taken based on my comments, and I strongly recommend seeking professional advice for your individual needs. My goal is to provide general information and support and not to provide legal counsel or substitute for professional expertise. Further, the questions and answers in this video were from the USCIS website. You can visit their website for more information. Now let's go over the frequently asked questions about K1 Fiance Visa. Question: how long does the visa process take? Answer: the length of time varies from case to case depending on the circumstances of each individual case. The time it takes each USCIS office and each consular office to process a case varies. Some cases are delayed because the applicants do not follow instructions carefully or they supply incomplete information. Some visa applications require further administrative processing, which takes additional time after the visa applicant is interviewed by a consular officer. Question: most immigrant visa applicants are using the paperless DS-260 online form. What about K visas? Answer: all K visa applicants are required to complete the online DS-160 or the non-immigrant visa electronic application. Question: how do I extend my petition? The I-129F petition is valid for 4 months from the date of approval from USCIS. The validity of the I-129F petition is routinely extended by consular officers to ensure that applicants have sufficient time to complete the processing of their case. Question: what happens if you get married after filing a K-1 petition but before I immigrate? If the beneficiary and petitioner are legally married after filing the I-129F petition, the beneficiary is no longer eligible for the K-1 visa. The K-1 petition cannot be converted into a CR-1 or an IR-1 spousal petition. The K-1 petition will be returned to USCIS. To continue the immigration process, the petitioner will then need to file a spousal petition with USCIS on behalf of the beneficiary. Question: should K visa applicants use Form I-864 or Form I-134? Since Fiance visa applicants are non-immigrant visa applicants, they should use Form I-134. They will need to submit a Form 864 to U.S. Citizenship and Immigration Services or USCIS when they adjust status to conditional immigrant in the United States after they are married. Question: do the same income requirements apply to all immigrant visa applicants even if they use Form I-134? The answer is no. The 125% minimum income requirement only applies when a Form I-864 is needed. Applicants using Form I-134 will need to show that their sponsor's income is 100% of federal poverty guidelines as required under Section 212A-4 of the Immigration and Nationality Act. Question: what happens after I am issued a fiancé visa? After your fiancé is issued a K-1 visa and enters the US through a US immigration port of entry, you and your fiancé must get married within 90 days of your fiancé's entry into the United States. Question: what happens if my visa is denied and my case is returned to USCIS? After a case is returned to USCIS, any further inquiries, including any possible further actions to be taken, should be made directly with the USCIS Service Center where the petition was filed. Additional information can be viewed on USCIS website. Question: why was my visa refused? There are many reasons a consular officer may refuse a visa. For immigrant and fiancé visas, the most common refusal is under 221G of the Immigration and Nationality Act. This refusal means that the consular officer did not have all of the information needed in order to process the visa application to conclusion, so the visa could not be issued at that time. When the required information is submitted in a timely manner, visa processing can continue to conclusion and the applicant does not need to reapply for the visa. Question: what are the rules about K-1 visas? K-1 visas are different than regular immigrant visas because the applicant must marry the petitioner within 90 days of arriving in the United States to receive immigration benefits. Also, petitioners are only required to show their income is at least 100% of federal poverty guidelines using Form I-134. Take note that if you're immigrating to the United States with K-1 visa, it's important you know you have certain protection. The International Marriage Broker Regulation Act, or IMBRA, the Violence Against Women Act, and the Department of Justice Reauthorization Act of 2005 established various protections for foreign fiancés and spouses of citizens and lawful permanent residents of the United States applying for K non-immigrant or marriage-based immigrant visas. Question: can I travel to the US for business or pleasure while my K-fiancé visa is pending? You can travel. However, you may be subject to additional scrutiny. Traveling under another visa status or the visa waiver program is not advised for K-1 fiancé visa applicants prior to the approval of their K visa, as they have already indicated their intention is to marry in the US. That's all for today, guys. Thank you for watching.